Can you hear me now?
Yes, Judge.
Yeah. Thank you. Yeah.
Judge, just a small matter of we're facing some technical difficulties with Mr. Waleed Dwela's camera, and I believe Mr. Michael Weeder would like to make a comment regarding the appropriateness of whether or not it's appropriate for Mr. Waleed to attend via audio only.
What does Mr. Dwela say about that? He wants to attend by audio only, does he?
That's correct, Your Honor.
Is there any difficulty with that?
My Lord, only this. Waleed Dwela, who is speaking on behalf of the claimant, is the claimant's son. It's anticipated that the claimant will need to be cross-examined. Waleed Dwela has had a considerable role in the preparation of the case documents, the pleadings, and we understand the witness statements in this case. And my Lord, I put it no higher than this. Obviously, I'm in the court's hands, but I don't relish the prospect of cross-examining Mr. Salem Dwela if I can't see him and I don't know if he's being assisted by Mr. Waleed Dwela. Similarly, I wouldn't relish the prospect of an audio-only cross-examination in any event. But those are my two concerns.
Yeah. What are the practicalities of getting visual contact as well as audio contact with Mr. Dwela?
Good morning, Your Justice. This is Mr. Dwela. I'm the son of the claimant, Mr. Salem Dwela. There was a technician, I believe, from the DFC just prior to this call, which tried to assist me in enabling the video. Unfortunately, there seems to be some permission issues from Lenovo, which is the brand of the laptop that I'm using, which he hasn't been able to alter or to change the settings on. So at this moment, the technician was not able to help.
Is there any other laptop you could borrow from a neighbor?
You're just afraid this is the only laptop that I have, which is my work laptop as well.
It's your work laptop as well. There's no other office or neighbor you could see if you could borrow one from, or go to some other office to conduct the hearing.
I'm afraid I'm at home at the moment, and I don't have access to any other laptop, Your Justice.
Right.
Yeah.
Sorry, carry on.
I was just going to say that the claimant, Mr. Dwela, is not with me. I'm the only one representing Mr. Dwela, and at the moment. So,
my Lord.
Yeah.
Where is Mr. Hang on a second. Where is Mr. Dwela, the claimant?
The claimant is in Rome. Mr. Dwela is quite old, so he asked me to I've been looking after the whole proceedings from day one, and
can we just?
So he's not able to join directly.
But he will be able to join for giving his evidence, will he?
I believe he will not be able to join.
Because if he is putting in a witness statement or an affidavit, then he must be available for cross-examination. Have you seen the proposed trial timetable which the defendants have filed in the process?
Correct. So what I can do, I can try and contact Mr. Dwela and see if he can get some help to join the team's meeting. As I said, he's quite old. He's not very technology friendly. So.
Well, hold on a second then. I just want to hear what the defendants say about this.
Yes. My Lord, obviously this is a case involving allegations of misrepresentation, in which Your Lordship will have seen from the skeleton arguments and the documentary evidence is entirely based on Mr. Dwela's recollection, because there are no other contemporaneous witnesses. It's the first, if I may say so, it's the first that we have heard that Mr. Dwela, Salem Dwela, was not proposing to attend the trial. I'm slightly concerned that if we do, well, whilst it may, obviously Mr. Dwela is a litigant in person assisted by his son, whilst it may in some circumstances be advantageous for me if we could rush Mr. Dwela onto a laptop in the foreseeable future and just get him giving evidence today. My concern is if he hasn't prepared for giving evidence today, that may not be fair to him. But certainly we were not aware that Mr. Salem Dwela was not proposing to attend to give evidence. If we had been aware of that, we may have taken a very different approach to this hearing.
Well, it's up to each party to decide whether they attend for evidence or not, provided that everyone is aware that the consequence of not appearing and not making yourself available for cross-examination may adversely affect the outcome of the case. But as I understand it, Mr. Salem Dwela is in Rome and might be able to join us for his evidence. What I suggest we do, Mohammed, are you there?
Yes, my lord.
I wonder whether we could take steps to make sure that Mr. Salem Dwela can be linked in some way. And would it be sensible to stop for me to go offline for 10 minutes while we try and see whether that can be done? Or will
I'll ask IT.
Or will it take much longer than that?
I will ask Ijaz to assist.
And you may need to contact with the help of Mr. Dwela Jr. To find out all the details of his father's laptop and links and so on. What I suggest we do then is to adjourn to, what time is it now? It's 10 past. Adjourn just for 10 minutes while we make these inquiries, and then see what happens when we resume in 10 minutes' time. Okay, Mr. Dwela, we're going to stop for 10 minutes.
Thank you, Your Justice. I will try to contact.
If you contact your father, but also make sure you contact the court officials. I'm not sure precisely who you'll be contacting, but if you stay online, my clerk will tell you how to proceed. So we'll adjourn now for 10 minutes till 20 past 1 Dubai time.
Thank you. Thank you.
Thank you.
Good afternoon.
Good afternoon. Mohammed, are you there?
Yes, my lord.
Where have we got to?
My lord, Mr. Waleed has reached out to Mr. Salem and has provided a link, but we are not certain whether or not Mr. Salem will be able to attend. Mr. Waleed had suggested maybe rearranging the trial timetable so that Mr. Salem will be able to take the cross-examination tomorrow. That would, however, require that Damac, the defendant's witnesses, provide their witness statements first. But I will leave. I believe Mr. Michael, Ms. Weeder has some comments on that.
My lord, as I understand it, and I'm sure I'll be corrected either by Mohammed or by Waleed if I'm wrong about this. As I understand it, there are two issues now. The first is Salem Dwela is, I understand, he's been sent the link, he's trying to log on, but at the moment he's not been able to. He doesn't appear to have joined us, and we don't know if he's going to be able to. The second issue, and this may impact on Waleed Dwela's suggestion that we take the evidence out of turn, is my understanding from what Waleed has been saying during the adjournment is that Salem Dwela does not have access to the trial bundle. It's not clear, given the comments that have been made by Waleed so far, that he would necessarily understand how to operate the case lines online bundle, and he hasn't been provided with a hard copy of the trial bundle. I understand that we've explored some options during the adjournment as to whether or not there could be essentially a fourth Teams screen share that Mr. Salem Dwela could see, but I understand there are technical difficulties with that. So to an extent, my lord, we're in your hands. I'm taking instruction from Mr. DeLange as to whether or not our principal witness, Mr. Kukar, is available to give evidence in this session. We had anticipated he was probably not going to be called upon until either the end of this session or tomorrow morning, but we're making inquiries. Certainly Mr. DeLange could introduce his statement today, and the court would have to be persuaded that the evidence should be taken out of order, but also that if we go down this route, that Salem Dwela will be in a position to give evidence tomorrow. My lord, those are my comments on where we are at the moment. I'm not trying to be obstructive. I'm trying to see what the issues are.
Yes, thank you. Mr. Dwela, is Waleed Dwela, is it?
Yes, my lord.
Yeah. What do you have any observations to make upon what the other side have said?
Just one point, Mr. Michael Weather said that Mr. Dwela does not have access to the bundle. He was sent the bundle. He's been, in the CC line for every communications, every documentation that was submitted. So he has access to that information. It's just that I'm afraid, I believe he would not be able to retrieve that information. As I said, he's not very, he's very old. He's not very technology friendly. So he's relying on myself to actually represent him.
Mr. Dwela, I don't know whether you've attended a trial before with cross-examination of witnesses, but if you haven't, I should explain that quite often during the cross-examination, documents will be shown to a witness and he'll be asked to comment, and maybe he'll be told, well, what it says in this document is inconsistent with what you say, or something like that. You understand what I mean?
I do, my lord, yes. I'm new to the system.
The problem then is that if your father cannot access the documents easily, not as a matter of technology, but simply because he is old and not used to the system, it's going to make that sort of cross-examination very difficult. And it's not, and I should tell you, it's not something that necessarily is to your advantage or the other side's advantage. It very much depends upon how critical the points are and what I take from the reaction or lack of reaction to them. What I wondered was whether this particular problem of accessing documents could be overcome by a neighbor coming to help for an hour or 2 hours, however long it takes, just to help access documents for your father. Do you think that might be possible?
My lord, yes, I do think that is possible.
That might overcome that particular aspect of the problem. I have in mind that apparently the young seem to be able to deal with these things better than the old. So if we can overcome that problem, then the question is whether what you say about the taking of the witnesses out of order. Are you in a position to cross-examine Mr. Kukar or Mr. DeLange at the moment? Mr. Dwela?
Sorry, my lord. Cross-examine Mr. Kukar. We have never seen Mr. Kukar.
No, but at the moment, the proposed timetable, which would be in accordance with normal situation, is that the defendant, well, the claimant's witness goes first. That's your father.
Okay.
And then followed by the defendant's witnesses, who are Mr. Kukar and Mr. DeLange. And the way that each witness would go would be they would normally expect to rely upon their statements they've made and then be cross-examined on those statements. Do you understand what I mean?
I do, yes, my lord.
But if we didn't take your father until tomorrow, would you be in a position to cross-examine Mr. Kukar today?
Yes, I would, my lord, yes.
And do you see any, from your point of view, any disadvantage in that approach? I'll ask Mr. Weeder separately from his point of view, but from your point of view, do you see any disadvantage in taking Mr. Kukar and Mr. DeLange before your father?
I do understand that, my lord, that this is probably the only feasible thing to do at the moment, as we may not have any other option given the circumstances. So I'll take it for what it is.
Mr. Weeder, from your point of view, do you see any disadvantage in adopting that approach, assuming, of course, that we can get Mr. Dwela access to the documents tomorrow with the help of maybe a neighbour?
My lord, I don't. I'm still taking instructions as to whether we can get Mr. Kukar on the call straight away. But if we can't, then we can certainly get Mr. DeLange to swear his evidence. In terms of any disadvantage, I don't think so. My lord, I would be reticent for this trial to go with Damac's evidence today and then to go part heard if Mr. Dwela can't make it, or to end up, well, it seems to me, my lord, there are a number of potential routes forward. If Mr. Dwela can't make it, and I think Mr. Waleed Dwela may wish to consider this, obviously the options are these: either the trial proceeds and Mr. Dwela can give evidence, in which case I see no real reason why we can't cross-examine him tomorrow. And hopefully we can get Mr. Kukar to be cross-examined today. Alternatively, we can start with Mr. DeLange and Mr. Kukar, but Mr. Dwela can't give evidence tomorrow, in which case the court's going to have to decide, and Mr. Dwela's going to have to decide whether to seek or grant an adjournment and on what terms. Or it all works swimmingly and Mr. Dwela can turn up and be cross-examined tomorrow. I mean, my lord, we don't know at the moment whether we can overcome the difficulties with the bundle and the access to the hearing. But if it is possible, then I see no difficulties with taking the evidence out of sequence. But I would urge the court to consider carefully before starting on well, it's up to Mr. Dwela whether or not it's up to Mr. Salem Dwela whether or not he gives evidence. But my lord, that's where we are.
I think one thing that occurs to me would be I think you've planned some opening statements before coming to the evidence today. I don't know how long that was meant to last. Do you have an idea?
Well, my lord, that was entirely subject to your lordship, because of course, Justice Giles, when he made the original case management order, when you confirmed it at the pre-hearing stage, suggested there could be skeleton arguments and written openings. Now, I was assuming that my skeleton argument would stand as my written opening.
I've assumed that everything you wanted to say has basically been said in the skeleton argument, and the same on the other side too, where we have an opening skeleton argument and also opening submissions in writing. So we would probably go straight into the evidence, basically.
That's what I anticipated. I mean, the only point
just let me cut across you. Sorry to interrupt. How long do you anticipate, making allowances for his age and so on, but assuming Mr. Dwela Sr. can get access to the documents, how long do you anticipate you are likely to take in cross-examination?
Making allowances for his age and access to documents, I mean, I'd normally like to think I'd be done in an hour and a half, but it might be closer to 2 hours, dependent on the access to the documents. Yeah. I'd hope to be quicker than that, but that's sort of a worst case, I think, my lord.
And at the moment, I note. Sorry, this is not irrelevant. I note your proposed timetable talks about having the afternoon of today, which is afternoon Dubai time, I assume, and then all day Monday.
My lord, I was going to ask you about that, because after I sent that proposed timetable in, we got an email from the registry stating that we were proposing to sit from 1 o'clock until 4 today and 1 o'clock until 4:30 tomorrow. So that may have to be revised down, and we may have to cut our cloth accordingly. But I'm in your lordship's hands as to the sitting time.
I presume we could, if anyone wanted to, run into the following day. From my point of view, and I don't know what the position is or your position.
My lord, I will have to check. I may struggle, but I think I could probably accommodate the following morning, UK time morning. So I could probably do 9 till 12 UK on the Wednesday, Tuesday. Sorry.
Yeah. Okay. Well, I think we ought to try and make the alternative to proceeding on the basis that we've suggested of having your witnesses first. The alternative seems to be adjourning the whole trial, and I think that's undesirable.
We agree for many reasons, but not least. My lord, I've just had a message from Mr. DeLange. Saying that if we are going to extend into Tuesday, he's going to have difficulties because he's got a medical appointment in the morning on the Tuesday, which gives me some difficulties because he's both in this case, he is a witness, but he's also my in-house instructing solicitor.
Right. Okay. And do we know yet whether Mr. Kukar and Mr. DeLange can give evidence today?
Let me just see. Mr. DeLange certainly can. I've just had an answer. Yes, we can both give evidence today.
Well, I'll just ask Mr. Dwela if he's happy to proceed on that basis. Mr. Dwela?
Yes, my lord.
I think what we seem to have arrived at, subject to any comment you wish to make, is that we proceed with the trial today. We make arrangements for your father with the help maybe of a neighbour, to have access to get familiar with the documents and be able to, tomorrow to give his evidence and be cross-examined by reference to documents. But meanwhile, we'll switch the normal order and take evidence from Mr. Kukar and Mr. DeLange today, this afternoon. This afternoon, Dubai time, this morning, European time. Are you content with that?
I have no objection, my lord. Thank you.
Very well. Thank you very much. Well, we'll do that. But meanwhile, can you do you need a few minutes to organize that someone from the IT department at the court can contact your father or a neighbor, or will you set that up after we finish today?
Yeah, sure, I can, my lord. I can contact my dad directly on the phone.
Do you want a few minutes now to do that, or do you want to do that after you've finished with the witnesses today?
It's up to you, my lord.
No, it really is. Whatever you know the arrangements with your father better than I do. So it's simply a matter of what you think would be most productive in terms of getting people organised.
We can do it
afterwards. Okay. I have to say, once we've started, if your father doesn't appear tomorrow for cross-examination, I would of course take into account his statement, but I'd also have to take into account the fact that he hadn't made himself available for cross-examination, not through his personal fault, but simply through circumstance. Do you understand that?
I understand, my lord.
Yeah, very well. What I propose to do then, and Mohammed, perhaps we can formally start the session, is start now on the basis that I will, let's get formally on the record, and then we can make whatever, and I will announce what the proposed plan is once we get parties formally before the court. So, Mohammed, I think you normally have a statement you want to read.
Yes, my lord. This hearing is in the matter CFI 083/2018 between Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is a litigant in person assisted by Mr. Waleed Dwela. The defendant is a litigant in person assisted by Mr. Michael Weeder.
Thank you very much. That's right, is it, Mr. Weeder? You are not appearing formally as advocate on behalf of your client, but you are assisting them.
My lord, the position I think is this, and we've had this question before a couple of times on this case, is the rules of the DIFC court do permit litigants in person to instruct counsel to attend as advocates, but I am not the legal representative for the purposes of the litigation. So, my lord,
You're
litigation
an advocate.
I'm an advocate only.
Yeah, that's helpful. Thank you. Right. I should then, now the trial is formally underway, what I should do is just set out what has been the result of some preliminary discussions before we formally started the trial. I'm not going to go into full details, but it arises out of the difficulty which Mr. Salem Dwela, the claimant, would have in accessing documents and making himself available for cross-examination today. His son, Waleed Dwela, appears for him today and has, as I understand it, indicated that he is content with the following changes from the normal procedure. Instead of his father, Mr. Salem Dwela, giving his evidence today and presenting himself for cross-examination, that will take place tomorrow. That is to say, on Monday, starting, subject to anything that happens during the course of today, starting at 1 p.m. Dubai time, which is 9 o'clock in the morning UK time, and probably 10 o'clock Italian time if he is in Rome. But we can check those timings. Before that happens, Mr. Waleed Dwela will take steps to try and ensure that his father has access to a laptop from which he can appear and be cross-examined, and has access to the documents on the court system. I always forget what it's called. If necessary, he will be able to obtain the assistance of a neighbor who is familiar with this sort of technology, having in mind that the claimant himself is fairly elderly and would not by himself be able to operate the system. The intention, therefore, is that he make himself available for cross-examination and any further examination in chief that he wishes to make tomorrow morning. That's the 6th of December at, as I say, 9 o'clock UK time, 1 o'clock in the afternoon Dubai time. That because of that, we will take the evidence of Mr. Kukar and Mr. De Lange, both witnesses for the defendant. We'll take them today after whatever opening statements either party wishes to make. Now, in terms of opening statements, I should say I have read, as you'd expect, the skeleton arguments and also the written submissions lodged on behalf of the claimant. And it may be that in light of that, there's no need for any great lengthy opening. But Mr. Dwela, I'll ask you whether you want to say anything more in addition to what you put in writing in the case. Mr. Dwela.
Yes, my lord. I'm okay with whatever it's in the skeleton arguments that my lord has read.
Thank you very much. And Mr. Weeder, I understood from your remarks earlier that you didn't wish to add anything to what's your written skeleton argument at the moment.
My lord, I'd only add one point, and that is this, and it's a question as to the scope of the trial.
Yeah.
Now, you will have seen from, and this may assist Mr. Dwela, who is about to cross-examine Mr. Kakar and Mr. DeLang. You'll have seen from Mr. Dwela's opening statement, and I'm going to give you some references. Are you using the case lines bundle online, my lord?
I am for some things and not for others. The documents like the opening statement I have downloaded so that I can, without having to go out of other documents to look at them.
Indeed.
Yeah.
So, my lord, paragraphs 36 to 37 of his opening statement.
Opening statement.
Opening statement, my lord. Mr. Dwela accepts that his claim for breach of contract has been struck out. And
yes.
he also accepts that that claim was not reinstated by the decision of the Court of Appeal. And I say he accepts it, but he must accept it because that is what they say.
Yeah.
He also accepts at paragraph 38 of his opening statement that the claim proceeds solely on the basis of misrepresentation.
Yeah.
But your lordship will have noted that Mr. Dwela's opening continues to allege, for example, delaying completion of the works, and continues to assert things like fundamental non-performance under the contract law. And so, for example, your lordship will see at paragraph 40 of the written opening, there is an entire section there.
Hold on a sec, sorry. It starts, paragraph 40 starts with the heading misrepresentation.
Indeed, but if you read paragraph 40 itself, whilst it starts with the heading misrepresentation, we have, in accordance with Article 5.1 of the agreement, the anticipated completion date was June, extension of 12 months, 9 years has elapsed, and then he cites Article 77 of DIFC Law 6 2004, which as your lordship will be aware is the contract law. And also the claimant's issue to be considered by the court, which starts at paragraph 47 of the opening statement. Yeah. Starts with the proposition whether there has been any delay in the completion of the project from the defendant. My lord, the short point I would make about that, and it may assist Mr. Dwela, is just to reiterate that Mr. Dwela's claim in contract is barred, so those are not avenues that are open to him at this trial. The second point that I would make is in relation to allegations of fraud, my lord. And you will see, for instance, that if you've had the opportunity to consider the decisions of the Court of First Instance and the Court of Appeal that are in the bundle, you will have seen that very often when Mr. Dwela comes to this court, he presents the claim and uses the word fraud a lot, and he says all the misrepresentations must have been fraudulent. At paragraph 42 of his opening statement, he raises the possibility that Damac may be guilty of deceit, and in his skeleton he does appear to assert fraudulent misrepresentation.
Maybe guilty of what?
Deceit, my lord, and that's paragraph 42.
Where is
the last
I didn't
line.
catch that. Deceit, as you say, yeah.
Is it?
Yeah.
Now he accepts that the Court of First Instance found that no case had been pleaded in relation to fraudulent misrepresentation. And he also accepts that the Court of Appeal held that no claim in fraudulent misrepresentation had been pleaded, and it was now too late to do so.
Mm-hmm.
Now, my lord, the point we'd make about that, of course, is no particulars. First of all, I should say, I'm bound to say, because Mr. Dwela is a litigant in person, that with respect to Justice Richard Field, when he stated in the Court of Appeal that no claim of fraudulent, that the Court of First Instance found that no claim of fraudulent misrepresentation had been pleaded, and it was now too late to do so. That's not an accurate characterization of the judgment at first instance. The judge at first instance did find that no claim in fraudulent misrepresentation had been pleaded, and he held that the extension of time permitted for claims in contract where it is alleged that the contract has been procured by fraud, so is the extension of the contractual limitation period, had not. It was now too late to bring a claim that he was induced by fraud into entering into the contract. But he didn't hold that a claim of fraudulent misrepresentation was out of time, there being no time limit for fraudulent claims in the law of obligations. When the matter came before Justice Giles at the case management conference, the court gave permission for Mr. Dwela to amend to include, if he so chose, allegations of fraudulent misrepresentation. And my lord will see that, if you want the bundle reference, at page G2, Golf 2 of the case lines bundle at paragraph 1. The problem that we have that has been raised in the defence and has not been remedied is there are no particulars of dishonesty pleaded in Mr. Dwela's particulars of claim. And my lord, the rules of the DIFC court, rule 17.43, are absolutely clear as to the requirements of any allegation of fraud, which is that a party must specifically set out the following matters in his statement of case. 1, full and specific details of any allegation of fraud, dishonesty, malice, or illegality. And 4, notice or knowledge of fact. My lord, that is not pleaded in this case. And the reason I raised that is simply to highlight that for your lordship's attention, because certainly Damac does not approach this trial as if it is on trial for fraudulent misrepresentation. There is no pleaded claim in fraudulent misrepresentation, and it may assist Mr. Dwela before he embarks on cross-examining Damac's witnesses to understand what the limits of his permissible claim are at this trial. So, my lord, those are the points that I would make by way of opening, and they're purely responsive to the points that Mr. Dwela has made in the skeleton and written opening.
Can you just help me? You were referring to one paragraph of the Court of Appeal judgment about giving him permission to plead fraud, or to,
no,
add to.
It is not in the Court of Appeal judgment. It's in the case management order of Justice Roger Giles, which is at page. You will find the order at page Golf 1 of the bundle, and you will find the specific direction at Golf 2, and it is paragraph 1.
Yeah, thank you. One sec. Yes, I see. Yep, thank you. Yep. Very well. I should ask Mr. Dwela if he wants to say anything in response to what you've done. Mr. Dwela, can you hear me?
My lord, yes, I do. I do understand. Sorry.
You understood what was being said by Mr. Weeder?
Correct. Yes, I do understand. I remember when we were given the possibility to plead for fraudulent misrepresentation, but at the same time, we were told that it would be a very, very difficult thing to plead. So at that time, we decided not to pursue that route. However, there have been other elements that were added during, like the submissions for this case, and I'm referring to the counterclaim dated May 2021, and this is what I think Mr. Wither was referring to in point 42 of the opening statements, where it has been produced a documentation by Damac for a revision of the 7th floor. That's where the unit was meant to be. The approval for the changes that would reduce drastically, the size of the unit was approved on the 27th of May 2010. So this is only 9 days after signing the SPA. So the point here is that Damac must have certainly been aware, because this kind of changes to the layout don't happen in 9 days. It takes a lot of planning. It takes architects that need to do the drawing. It takes authorization. They need to speak to their contractor. So all of these elements couldn't have possibly happened within 9 days. So this is why I put that paragraph in there. As I said, I don't want to plead, because I understand I'm not able to plead at this moment on time fraudulent misrepresentation. I'm just leaving the option open, as in whether at the time of signing the SPA, Damac was aware, they were already aware of the changes that were going to affect the size of the unit. So the claimant actually signed the SPA when Damac was already aware of the changes that were going to occur on the 7th floor that would drastically reduce the size of the unit, because they were meant to increase the number of offices and adding a storage facility within the area that was initially designated for the unit. So this is what I meant. I understand I don't have perhaps the legal knowledge, and perhaps that fraudulent went into the submission, but I understand what Mr. Wither is saying, and we're not going to add anything in that respect in terms of fraudulent misrepresentation. We're pleading. Sorry, my lord.
Carry on. Carry on.
We're just pleading here for misrepresentation. We understand that the breach of contract, as well as Mr. Wither suggested, has been time barred. So we would not be able to pursue that claim as well.
Well, that's helpful, because it makes it clear. I'm just saying this for the record, that you recognise that the breach of contract claim can no longer be pursued because it's been struck out for being too late, and you also recognise that you have no claim in fraud, and therefore, insofar as you're relying upon anything, such as in paragraph 42, that's not in support of a fraud case, it may simply be relevant to the question of fact as to whether there was a misrepresentation or not. Understood it correctly?
That is absolutely correct, my lord. We're just saying we don't know at this stage where Damac was aware of the people drafting the SPA. In Damac, their legal team was aware of the changes that were already authorized, or they were going to be authorized. So, like the authorization, they already asked for the authorization for the changes. So we cannot claim with any evidence that this is fraudulent, but we know that there has been a mistake that has really penalized the claimant.
Okay, thank you very much. But I think, Mr. Wither, I don't think there's any need for you to respond to any of that. And the next thing, therefore, is to come to your witnesses. Do you need a bit of time to get them organised, or are they all there and ready?
My lord, I'm told that they're all there and ready. If I can just explain to you what the arrangements are that we've made for our witnesses. We have an office set up in Damac's offices with the trial bundle available. I believe it's in hard copy for the witnesses. At the moment, we have one video link. It is showing on your screen as Julian DeLang. He is my legal witness. Then I say legal witness. He's the in-house counsel who will give evidence as to the document searches, and then Mr. Ali Kukar, who is the broader witness. They're going to swap places. So Mr. DeLange will leave the room and take himself off to a meeting room somewhere else, and Mr. Kukar will take over and give his evidence from the same video feed, if that's clear.
I see.
So,
and which one is giving you first?
My lord, given that we're taking people out of sequence, I would normally go with Mr. Kukar first, but I've been asked if we can take Mr. DeLange first. So, my lord,
No difficulty. Hang on. Just check there's no difficulty with Mr. Dwela about that. Just taking Mr. DeLange first.
I
Mr.
have
Dwela?
no objection, my lord.
Thank you. Yes, Mr. Reader.
Well, my lord, the defendant calls Mr. Julian DeLange. If he can turn his camera on.
Good morning, sir.
Good morning, Mr. DeLange. Are you happy to swear the oath?
Yes, I am, sir.
If you repeat after me, I swear by Almighty God
I swear by Almighty God
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. Yes, Mr. Weeder.
Thank you, my lord. Mr. DeLange, can you turn to page C2, C58 of the bundle?
Yes.
Mr. DeLange, is that your?
Can you just give me a second to make sure I just want to, I've got the witness statements in a slightly different form, so just give me a second.
Of course, my lord.
Yeah.
So, Mr. DeLange, do you have page C58?
Yes, I do.
Is that your witness statement?
Yes, it is.
Have you read your witness statement recently with a view to giving evidence in this case?
Yes, I have.
Can you turn to page C61
Yes.
of the bundle? Is the signature on that page your signature?
Yes, it is.
And Mr. DeLange, can you confirm that the facts stated in the witness statement are true to the best of your knowledge and belief?
Yes, they are.
Well, Mr. DeLange, if you will wait there, it may be that Mr. Dwela or the judge have some questions for you.
Mr. Dwela, this is your opportunity now to ask Mr. DeLange questions about his witness statement or any other relevant matters.
My lord, would it be possible to get 2 minutes just to, just to get 2 minutes to review very quickly? Again,
Yes.
Mr. DeLange statement. 1 second.
Yes, of course.
Thank you.
Do you need more than 2 minutes?
Perhaps 5 minutes, yes.
We'll just stop for 5 minutes. I'm going to mute myself and come back in 5 minutes.
Thank you. So,
Mr. Dwela, do you have the right bundle now?
I believe I do, my lord.
Thank you. Right, Mr. DeLange's statement is in section C.
Section C. Okay, so yeah,
It's
witness
the
statements. Yeah.
5 is witness.
Number
First witness
5.
statement is in DeLange.
Thank you very much. I have it in front of me.
Right. Are you ready to go ahead, or do you need 2 minutes just to check through it?
Just another 2 minutes, my lord, if that's possible.
Okay.
I'm okay, my lord. There's no question on my side. It's pretty straightforward.
You have no questions you want to ask of Mr. DeLong?
Not regarding this particular witness statement, my lord.
Right. Well, this is your opportunity of asking any relevant questions to Mr. DeLong. So you have no questions, as I understand it.
I have no question relating to this particular witness statement.
Well, you say that. I just want to be clear. This is your opportunity to ask Mr. DeLong questions relating to the case, even if they don't appear in the witness statement. So if there's anything relevant you want to ask Mr. DeLong, this is your opportunity.
I understand, my lord. I'm okay to continue.
To continue with the next witness, or with this witness.
With the next witness.
So I didn't hear you.
With the next witness, my lord.
Very well. There's no cross-examination, Mr. DeLong. Therefore, you're free to step down now. And if you could get Mr. Kukar, is it, into the room in your place. Thank you.
Thank you, Your Honor.
Mr. Dwela, for your reference, the next witness's statement is at number 3 and number 4 of that same section, section C of the trial bundle.
Thank you, my lord.
Good morning, my lord.
Good morning.
My name is Ali Coker.
Yes, 1 second. Are you happy to take the oath, to swear the oath about your evidence?
Yes, my lord.
Will you repeat after me? I swear by Almighty God.
I swear by Almighty God.
That I will tell the truth.
That I will tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you very much.
Thank
Yes,
you.
Mr. Wheater.
Mr. Kukar, do you have the trial bundle in front of you?
Yes, sir.
Can you please turn to page C21?
Yes.
Is that your first witness statement?
Yes, sir.
And can you please turn now to the back of that statement, which you will find at page C50?
Yes, sir.
Is the signature on that page yours?
Yes, sir.
And have you read your witness statement recently with a view to giving evidence in this trial?
I have, sir.
Can you confirm that the contents of the statement are true to the best of your knowledge and belief?
I believe so, sir.
Well, Mr. Kukar, if you just stay there, Mr. Dwela, and then maybe the judge will have some questions for you.
Sure.
Sorry, I have to. Sorry, Mr. Kukar, I have to introduce your second statement. If you can just have a look at page C53 of the bundle.
Yes.
Is that your second witness statement?
Yes, sir.
And can you turn to page C56?
Yes, sir.
Is that your signature on that page?
Confirmed. That's my signature.
Have you read this second witness statement recently with a view to giving evidence in this trial?
I have.
And can you confirm the contents of this statement are true to the best of your knowledge and belief?
Confirmed.
Now while you wait there, Mr. Dwela might have some questions for you.
Yes, Mr. Dwela, do you want to ask Mr. Kukar some questions?
I do, my lord. I just, again, it would be very helpful if I can have another 5 to 10 minutes. I wish to rely on the reply to the witness statement made in our submissions.
Right. Well, I think given we are probably have caught up and we're ahead of time, I think we can allow you 10 minutes. Is that all right, Mr. Wheater? Mr. Cook, can I ask you to stay there? You can go out and get a coffee or whatever, but make sure you're back in 10 minutes. Could you please?
I will, my
Thank
lord.
you.
Thank you.
I'm going to mute myself and disappear from the screen.
Thank you. Thank you, my lord. It's going to be a bit complicated for me to actually question Mr. Ali. I have a few questions, but I was thinking about preparing my question for the witness today, obviously because of this swap. You know, it's very difficult to go through the document and ask the question that I wanted to ask, but I understand. So we'll just go with.
Well, I should say that in our discussion earlier, I was anxious to make sure that you had no objection to changing the witness order. And if you feel inconvenience, that's something that should have been pointed out at that time. Nonetheless, I think if you take the course you want to take with this witness, if you need a break for 5 or 10 minutes at any stage during the cross-examination, please ask and we'll see how we're getting on. All right, so if you start off.
Yes, hello, Mr. Ali Kokar. Thank you. Thank you for being here today. So the first question that I have is, what is your relation to the claimant? Because you know, you have a lengthy witness statement, you know, acknowledging the facts that have occurred, but it doesn't seem that you have ever met the claimant, or you've been involved in the sales transaction, or dealt with the salespeople that interacted with the claimant. So I just wanted to make sure to understand, you know, your position on this case. You know, because in order to provide a faithful testimony of the events, I understand that you know, you should have been you know, part of this events, or at least known some of the people that we claim made the misrepresentation to the claimant.
Okay, Mr. Walid. To this particular case, I don't have any involvement. However, I am the CRM department, customer relations, and I was asked by our legal to help him collect documents for this particular case. And I've given my witness as a general information about the company, how we deal with customers, kind of situation. To this particular case of Ms. Dwela, I wasn't involved, neither in the sales or in the.
Thank you. I appreciate that. Just wanted to ask you, when did you start working for Damac? Were you working in at the time of the signing of the you know, purchase agreement, 2010?
I was in Damac, yes, but I was in a different. I was in business development department.
Okay, thank you. In relation to the sales team that Damac you know, uses to sell their projects to potential you know, buyers, you stated in your witness statement that these people are not employed by Damac, but they're just transitional staff that are provided with basic trainings, and so I would assume they have no accountability towards Damac. Is that a correct statement?
What I stated that they're commission based. Whenever they sell a property, they get commission on the property value.
But what is the level of training that these people get, and is there any kind of accountability in terms of what they say to the clients? I mean, is there like a department that oversees them?
Regards of sales, I'm sorry, I cannot help you there. But in regards of training, they get an induction to the company and updates of the project training, like getting to know the areas of Dubai where our properties are and the facilities of the towers and developments.
Okay, thank you. Just give me 1 sec. So, in our pleadings, we stated that a particular salesperson, Mr. Fahani, made the misrepresentation to the claimant first for Damac Heights and then for Park Towers. So you stated that you never met Mr. Farhani. And what is the position exactly of Mr. Farhani? Is he an employee of Damac, or is he part of this external stuff?
Actually, he, if I'm not mistaken, he was a commission-based. Again, what I'm talking about is general knowledge. This particular guy, I've never met him, as I don't deal with sales.
Okay, thank you, Mr. Ali. So your entire witness statement is based on what exactly? I mean, I'm sorry if I say that, but you have never met the claimant. You were not aware of the events. No, you didn't take part, sorry, in the events that occurred at the time. You have never met any of the salesperson that were related, that had interaction with the claimant. You were working at the time in a different department in the MAC. So exactly what did you witness?
My witness statement is basically on the SPA signed by Mr. Dwela and by the emails exchanged in our company and documents.
Okay, so the
which I've shared with the legal department.
Absolutely.
And based on general customer service, what we accommodated it, a general idea.
Thank you very much, Mr. Kukar. So the weight of your witness statement as such, would you say is the same as any other employees that had access to information provided by the MAC that you have in your database? I mean, what makes your witness statement stand out?
I'm sorry, Mr. Reid, I don't know what to comment on this question because that's in the court's hand to take the weight of my statements.
Yes, sure, Mr. Kukar. So in other words, what I'm saying is any other employee in Damac could have made this witness statements provided with third party with the information provided by Damac from the emails, correspondence, and other relevant documents. So I just wanted to understand exactly why it was you, Mr. Kukar, that made those made that witness statement, knowing that you're not part of the events that occurred. So that was the question.
I'm not a part of Mr. Dwela's case when it happened with Damac, but I'm a part of the company that looks after all customer relation management. So all of these documents and all the SPAs are under me now. That's why I was, and I have a long experience with customer relations now.
Thank you, Mr. Kukar. So thank you. That's it for now. From my side, I understand that all the information provided on the witness statement are information that are could have been used by I think any employee in the MAC to make up a witness statement. This information were available and were in possession of the MAC's lawyers, I believe. And I understand that you didn't take part in any of the events, you know, for the purchase of the unit in Park Towers. I would have had many other questions, Mr. Kokar, but I understand that, you know, I might not have the time to go through the witness statement as I was planning to do that today. So thank you very much, Mr. Kokar.
Well,
Thank you, Mr.
Mr. Dwela, I'm not going to leave it there. If you have questions you want to ask, you must ask them. If you don't ask the questions, I will assume there are no relevant questions you have to ask. Do you understand? It's unfair to both parties if it's left on the basis that you would have had more questions, but don't have time to carry out the research. If you want to take half an hour to consider more questions, please do so. But this is your opportunity.
My lord, that would be very, very helpful if I could have 30 minutes just to review the witness statement and come up with some questions.
Mr. Weaver, I assume you don't object to that?
My lord, I don't object to that. Just in relation to Mr. Dwela's suggestion that he should come up with some questions. He shouldn't be obliged to ask questions if he hasn't got any.
No, he's not obliged to ask questions, but I don't want it left on the basis that had he had more time and had we not changed the sequence, he would have had more questions.
I understand.
Very well. Can I ask you, Mr. Kukar, to feel free to leave the room, but can you come back in half an hour? Let's make it precisely at 12 o'clock UK time, which is 5 o'clock, 4 o'clock. What time is it?
My lord,
10 to 3 in UAE, my lord.
It's 10 to 3.
In UAE, yes.
All right, sorry, I was misreading my watch.
I'll make it 10 to 11, my lord, here.
Yes. We'll resume at 11:30 UK time, 3:30 Dubai time. Is that right?
Thank you, my lord.
Thank you very much.
Thank you, my lord.
Is everyone back, present? Mr. Dwela, are you?
I am indeed, my lord.
Thank you. Are you ready to proceed?
Yes, I am, my lord.
Thank you.
I would like, thank you very much, my lord. I would like Mr. Ali Kukar to comment on point 42.1. Let me just, from the witness statement. I'm just gonna pull this. So on this point, he states that the SPA for the sale of a commercial office unit on the 7th floor of Park Towers, he explains how the floor is structured and the position of and the swimming pools are constructed rising from the 7th floor slab and so on. I just wanted to ask the witness here if he saw the plans for the podium that were attached to the SPA, where it's indicated that the unit will be on the 7th floor below the pool podium.
Yes, sir. I have seen the floor plan.
Okay, and can you ascertain, you know, having looked at the plans, can you ascertain that is clear for the claimant to, you know, to ascertain that the unit is below the podium? Is it stated anywhere on or highlighted anywhere on that map that the unit was going to be on the 7th floor, and that 7th floor is it was going to be obstructed by, it was going to be under the podium that sustains the swimming pool?
I'm sorry, I didn't get the question.
So the question is, having seen the drawings of the floor plans in the SPA, can you ascertain that it is clear from the claimant point of view, from reading the SPA and looking at the drawing of the floor, that the floor was going to be under the podium that sustains the swimming pool, and that the unit was going to be on the 7th floor? Is there anywhere highlighted on that drawing? Is that information being highlighted to the claimant?
My lord, would it be helpful if Mr. Kukar was taken to the drawing? It's the drawing, I believe, is being referred to as page E81 of the bundle.
Should we have a look at that?
I'm sorry, my lord, I'll just need a couple of seconds.
E81.
Okay, here as I mentioned, it clearly shows that where the office is, and it's written P7A on that page, and Mr. Salem Dwela has signed it on the SPA.
Because
What was mentioned to him during the sale, I cannot be a part of. As I mentioned before, I wasn't involved in this agreement.
Because from the claimant point of view, the drawing were not clear, and it was not clear from looking at the drawing that the unit was going to be below the pool level, on the podium below the pool level, sustaining the swimming pool. So basically, he obtained an office which had almost no daylight, with no view over the pool. So
but Mr. Walid, as mentioned in his SPA, which he's acknowledged and accepted, there is no view written that he will have pool view. And secondly, once Mr. Dwela has signed it, that means he acknowledges and accepts the floor plan. So if it wasn't clear on that day or that part, I mean, again, I cannot comment on this. I wasn't there at the sale. But what I can see as per the SPA, he has signed it and accepted it.
it is correct that the ESPA does not mention anything regarding the pool view, but I do understand that a case of misrepresentation can be made based on oral, statements made by a salesperson, that in order to induce the claimant into an agreement has made false statements or perhaps just statements regarding the view of the unit. In this case, it was told that the unit was going to overlook the swimming pool when in fact it was not.
Again, Mr. Walid, I cannot comment on that. I wasn't there in the sales.
Okay, that's fine. And then on point 42.2 of your witness statement, you say the particulars of this SPA show that the total area of the unit was 2,402 square feet, and also that the permitted use of the unit was office. This is important, you state, because clause 10.10 of the SPA explains that where a unit is an office, the total area includes both the internal area of the office unit itself and also a proportion of the common office area shared by all the office units. So my question here, Mr. Kukar, have you read the SPA clause 10.10?
Yes, I went through it.
Sorry, I didn't get that. You did?
Yes, I've gone through the SPA.
Okay, perfect. So if you read, you know, like the SPA clause 10.10, it says, however, if the permitted use of the unit is office, then the total area of the office unit includes, for the purpose of calculation of the purchase price only, that part of the common office area which is attributable to the unit as described in clause 1.1 of this agreement. But it's, sorry, it says that basically the common area is calculated only on the basis of the purchasing price, and it says only. Okay, so it does not state anywhere in that clause 10.10 of the SPA that the common area should be included as part of the total area when it comes to calculate the size. It clearly states that the total area is the net area. Have you read that clause? I mean, do you agree with that?
Mr. Walid, I'm not in the position to agree or disagree. I'm just stating the SPA that's written by our legal department. So
I understand. I understand. Thank you. But it clearly states that the calculation of the common area is exclusively for the calculation of the purchasing price only, and it states that word, and it says that the total area is the net area. But I've seen not only in your submission but also in other submission by Damac that they keep on quoting this clause just by taking parts of it, never taking like the you know, like this clause in its entirety. I mean, if it's quite clear that the total area is the net area, then a lot of the estimate of the area that has been provided by the MAC is wrong, because the MAC keeps on asserting that the total area should be calculated with the net area plus the common area, and so their calculation is based on this. So I think this is a big you know, disagreement that we're having with the MAC, because I think they haven't read properly that clause in the SPA. I don't know if you have anything else to comment on that.
this question can be answered by our legal counsel, Mr. Julian, because as I told you, this is the legal department, the SPS.
Okay, that's absolutely fine. Thank you very much. So then moving on to 42.4, it says, okay, you talk about also later on in your witness statement, you talk about design, you know, design changes that could delay the project. So are you aware of the design changes that were made for which the MAC received authorization from the relevant authority just 9 days post signing the SPA, that changed completely the size of the unit of the claimant and the entire layout of the 7th floor by creating more office space and adding an additional storage inside the unit of what was meant to be the unit of the claimant?
That usually is handled by our project team with the local authorities. Okay, and always in our SPAs we mention that because it's an off-plan, you may face some changes in the master community or the development itself.
Okay, that's fair enough. And are you aware of any protocol, let's say, or any how do you say, disclosure that the MAC would have towards their you know, the purchaser in terms of providing this information? So let's say, you know, obviously we're pretty sure here that, you know, like this has been studied and designed and drawn and all the authorization and sort of discussed way before the signing of the SPA, because it's impossible that it could have occurred within 9 days. Obviously, having received the authorization 9 days post signing of the SPA, it means that this design changes were programmed and planned way before. But are you aware that Damac, what's the protocol or in Damac about informing the purchaser about changes that might affect their unit?
I am not aware of this protocol.
Okay, so there isn't one.
Again, I'm not aware of it because it's done by our projects team.
Okay, that's fair enough. So okay.
Can I just interrupt for a second? Mr. Kuka,
Yes, ma'am.
the question proceeded on the basis that if approval was given 9 days after signing the SPA, then clearly there must have been discussion about within Damac. There must have been discussion about the changes well before the SPA was signed. Do you agree with that? Do you?
I agree with that, my lord, but I'm again not aware if the salesperson was informed or not, because I was not there.
I see.
So maybe,
but I was really leaving aside who was party to that discussion within Damac. There would have been people within Damac who discussed the changes, proposed changes, before the SPA was signed.
that would be our project. That would be our projects team.
Yeah, projects team, but they would have been. I mean, put it the other way, you don't get approval 9 days within 9 days of first asking for approval. There must have been a request for approval before the SPA was signed.
I'm sorry, I didn't get you. You mean there would been an approval request from ours to the local authorities?
Well, the approval was given 9 days after the SPA was signed, I think. Approval for change of layout.
Okay.
Yep. That approval must have been, the process of getting that approval must have been started well before the SPA was signed. Is that right?
I'm not sure, Your Honor.
Is it even possible? Sorry,
because all the changes in design, everything is handled by our projects department.
Yeah, but
So
to get approval would take more than 9 days, wouldn't it?
I guess so. I really can't answer that.
You can't answer. Okay, thank you. Yes, sorry, Mr. Dwela, I interrupted you.
Thank you, my lord. Yeah, I wanted to add not just the approval would take more than 9 days, but also the planning and the drawing and the discussion, the checking the feasibility with the contractor regarding changing an entire plan. That takes months of discussions. But thank you, Mr. Ali. Also, you discussed as well that obviously that constructions or projects are complex. You say in your point 48.1, and there are often delays in constructions. Do you know what might have caused the delay with the contractor? And you think that the changes that happened that we know about on the 7th floor, we don't know if there were changes in other floors as well, perhaps residential and or office, but if obviously after signing the SPA, this changes must have occurred. So do you know if perhaps those changes are the ones that led to the delays from the contractor, to finish the building? Because you also state that the revised estimated time of completion for the contractor initially and this was the revised one, was in 2009. Okay, and then you in your statements, as again, you said that by October 2010, the contractors stated that their estimated time of completion would be October 2010. So when Mr. Farhani made the representation, do you think it's possible that he used that date, which is October 2010, that you put in your witness statement, as you know, like you know, the time whereby the building would be complete, and so you know, so that the claimant would be induced into that understanding. So because October 2010 is about three to 6 months after the signing of the SPA.
I know, Mr. Wali, but I don't think so Mr. Farhani would said this, because in the SPA on page 2, clearly written anticipated completion date June 2011. So I don't believe the salesperson would pitch something that is completely going against the SPA where Mr. Dwela has signed it.
But you're obviously aware of that, because you put that in your witness statement, right? That the estimated completion date for the contractor was going to be October 2010. So do you believe that perhaps Mr. Farhani would have had the same understanding?
I don't believe that, because the information that they are given by marketing departments are only the information that are written on our SPA.
Okay. And how does Damac prevent their salespeople from making misrepresentation? I mean, you know, like, I mean, you know, somebody that is not overseen, or like that there isn't anybody accountable as to what the salespeople say. I mean, how can you ascertain that you know, Mr. Farhani or any other sales representative couldn't possibly have made such representations?
If we are not involved in the meeting where any verbal promises are given, which I highly doubt they are, if anything official is given by email, or then we investigate on it as a customer relationship head. But anything verbal said to any client by the sales, which again I highly doubt they do, because everything is documented now, I don't believe that anything verbal would have been, in my perception, said to Mr. Dwela.
Absolutely, and thank you for that. So going back to that point 48, do you know what could have caused the delay in from the contractor point of view?
What I know, there was some arbitration happening between the contractor and Damac, which I'm not informed about, because it's or which we cannot discuss it because it's confidential.
Mm-hmm.
That could have been the cause of the delay.
Okay. Okay, that's okay for me. Let me just Mr. Ali, are you aware of, you know, like obviously you have a very lengthy witness statement. Are you aware of any updates that were sent to the claimant mentioning that there would be any delays from the contractor? Because we haven't seen any. And also, are you aware of any updates that were sent to the contract any emails that were sent to the claimant saying that there would be changes into you know, the layout of his unit that would lead to a very reduced size of the unit? So I just wanted to ask you that, if you're aware of that.
I'm aware that there were emails sent to Mr. Salem regarding the project update and progress.
Okay, but those project updates were just general, regarding the building. But are you aware if there were any specific updates regarding his own unit and the fact that it would be drastically reduced? Because the claimant affirms that the first time that he sees a different size in the unit, like stated by Damac, was in the statements of account of January 2012. That's when the handover commencement email was sent, where the unit was depicted as 972 square foot. Then it was corrected in February again with the wrong size again, mentioning the original as per SPA 2,400 square feet again. And obviously that, we believe, was made in order to induce the claimant to sign the handover with the second statements of account. And then there was another statement of account, again, stating the area as 1,500 was it 1,530, I believe, 70, I believe, square foot. So are you aware of these, all the statements that were sent to the claimant at different stages?
Yes, I've seen the documents of it.
Okay, because in your witness statement again, you state, I believe, you state that you don't understand why the claimant did not sign the handover, when he was asked to. So I'm just asking you, would you sign a handover after you receive different statements of account? Without being able to see the property, and obviously after seeing the property you realize that is not what you have signed in the SPA. Is a much reduced size. So just
I'm sorry, Mr. Wali, but that's not my position to answer that, because that's a personal question if I, as a client, would sign or not. It's a very individual decision.
absolutely, I understand. Let me just pull. Okay, because you state on point 77, accordingly, a revised completion statement was issued on 23rd of February 2012. You did not mention there that it was the wrong size, again, that it was sent. And then you said Mr. Dwela did not take any steps to commence the handover process. So, yeah, I just wanted to get some feedback on you, whether, like, how can the claimant actually sign the handover process when he's getting sent all these different statements of account with different sizes, and he's not allowed to, because from January until March, he was told by Damac staff that he signs the handover and then he will be let inside the unit for the viewing. So it wasn't until March that he was let inside. And then he was sent another, again, statement of account after that, after viewing the property, for a different size. Again, not only that, but also the claimant was not provided with the changed drawings. After the changes happened for the layout on the 7th floor, they reduced his unit. He was not provided with the drawings of or the map of the 7th floor after the changes. And when he had asked, and this has been provided in the exhibits in the documentation by both ourselves and Damac, when this was asked, the reply was, first you sign the handover, and then we will provide you with the final drawings.
What's your question?
So the question was if the witness was aware of this, because you seem to be mentioning that that the completion statement was issued on the 23rd February, but you don't mention that it was with the wrong size as well. So I just wanted to understand whether the witness had access to that information.
Again, my witness statement was based on the documents I've seen because the handover is handled by our handover department, and they have their process.
Okay. Yeah, because okay, that's fine. Just give me 1 second. Yes, so in point number 84, you say, I'm not involved in the construction aspect of the company, but from the records I have seen, I understand that the size of Mr. Dwela unit was reduced as a result of the addition of a storage area on the 7th floor. So I understand that you recognize this. Then you say, I refer to the construction plan, which shows Mr. Dwela unit highlighted yellow and the new storage area. Now, are you aware that this was not shared with Mr. Dwela until 2017?
I don't have information if it was shared before that.
Okay, because the floor planning and the drawings of the unit were provided by the DIFC on an email to Mr. Dwela in 2017. So Mr. Dwela had no idea of any of the changes that occurred. He was never informed by Damac or his or Damac's representatives, and it was not until 2017 that we had access to that information. Just give me 1 sec.
Can I just interrupt for us while you're looking at Mr. Wheato? Can you help me? The references in the witness statement to, for example, in paragraph 85 to AHK 11. Where do I link that with any of the productions? AHK stands.
I'll just get the reference for you for AHK 11. The document that Mr. Dwela is talking about at the moment is at E499, which is the version of the plan that was sent by the DIFC.
Yeah. E499.
E499.
Yeah. Yeah, thank you. But throughout the witness statement, there are references I can't quite pick up.
The two witness statements, and it's not entirely clear, and we'll see if we can get you a cross-referenced index overnight if that's possible. The original exhibits to the witness statements have been compiled as a chronological exhibit bundle, so the references in the witness statements don't correspond to the trial bundle, I'm afraid. But my lord, the specific document referred to by Mr. Kakar in his statement, I believe, is at E159, which is the drawing showing the
Yeah.
That's the version with the office area shown in yellow, and the storage area shown in green.
Yeah, thank you. If perhaps sometime before tomorrow morning you could give me just a list of the comparative references in the witness statement, that'd be useful.
We'll get on.
Yeah. Yes, sorry, Mr. Dwela, I interrupted your questioning.
Thank you very much, my lord. I just have another couple of questions. Point 86 of the witness statement. I know that Mr. Dwela complains that he should have been told about the potential change to his unit. So I believe that the witness understands that, you know, like not updating, you know, the purchaser of any changes to the unit. It's you know, it's quite bad in a way, you know, and it would constitute, in my view, you know, a misrepresentation as well, because Mr. Dwela, you know, until the handover commencement was under the impression that the unit was going to be the one as set in the SPA. You state that I would not expect the sales representative, Mr. Azadi, to have known that there were any proposed revision to the design. Okay, but I understand, however, from what you said before, that the sales staff would have had some induction, or at least would have been kept updated with regards to any revisions that occurred to the floor, and that would affect the unit of the unit of the purchaser. So my question here is, again, is I understand perhaps that the sales staff would have not had visibility, but don't you think it is a failure from the side of Damac not to provide this updates, which are critical, I would say, you know, for a company like Damac, you know, to have transparency and to provide these updates to the purchaser?
So this is something got to do with projects department and our sales. So I'm not, I don't see how I can answer that question.
Okay, so you don't see a failure from Damac in informing their sales staff, you know, about any changes into, you know, like the layout of a floor that might drastically affect the size of the unit of the purchaser, right?
I believe I don't have to answer that question. It's a personal opinion if it's a failure or if it's a accomplishment.
Okay, I understand. I mean, okay. Just okay, then in point 87.2, you state, rightly so, that there is a mechanism to revise the purchase price to take account of any changes in size. I have read that myself in the SPA. If the as-built unit is larger than expected, the purchase price will be revised upwards. If the as-built unit is smaller than expected, the purchase price will be revised downwards. Now, you say more specifically for Mr. Dwela case, if the as-built unit is more than 5% smaller than set out in the SPA, the MAC is obliged to credit the purchaser an amount to reflect that reduction. Now, the claimant actually received a statements of account, and that was that I've seen in February 2012. So that is 1 month after the handover notice. Now, the MAC claims that this was sent in December 2011, but I failed to see that. But where a credit was provided into the account of a credit that has never been, you know, cashed, but is just, you know, put into the statement, where it was recognized that the unit was smaller than what is expected. Obviously, we don't agree with the measurement done here by the MAC, but you know, there was no update whatsoever as to why the claimant was receiving that money. So is this like a normal sort of standard procedure within the MAC, sort of to send the statements of account with a credit into the statement and not provide any context of what that credit is?
All the calculations of the area variation, if it's bigger or smaller, are done by our finance team. So the finance team sends the updated statement of account, okay, as a procedure, what I know. And then any questions or any regarding the statement of account or payments, it's the client gets in touch with our contact center or sends us an email, then they reply based on the query of the client.
Thank you very much. Thank you. I do see, like in that statements of account, the variation. You know, like the line where it says variation. But again, this is not put into context, so the claimant doesn't know what that is. Because there's no letter or an email or any kind of justification for that, or like there's nothing that puts that change and variation into context. So so just wanted to check whether with you, but you already answered whether there was like any, you know, again, any standard procedure within the MAC to inform with regards to whenever there's a variation to inform the purchaser about that. So thank you very much. Yeah, then on point 90, again, you say you refer to the DFC final floor plan of the unit provided to Mr. Dwela by email dated 19th of April 2017. So again, I assume that you accept the fact that this was not shared with the claimant before April 2017. Is that correct?
As per the documents provided to me, I see that Mr. Dwela got it through the DFC floor plan in April 2017.
Okay, thank you very much. And sorry. And on point 91, you state again the complaints of the claimant regarding the total different and total different areas of the unit that were portrayed by the MAC. So you recognize that obviously there is evidence for this as well, but you recognize that basically there were at least 3 different sizes that were portrayed by the MAC after the notice of completion. Is that correct? Because it's written 91.1 and 91.2.
I've stated in my witness statement.
Okay, okay. So you do recognize that. Okay. Another thing, and it's something that is you are aware as well of the measurement that was done in 2018 by the Cavendish Maxwell independent surveyor, you know, that was accepted by both claimant and defendant in order to measure the unit size. Are you aware of that? Yes?
No, could you repeat the question, please?
Yeah, sure. So in 2018, both the claimant and the defendant agreed for a third-party surveyor, independent surveyor. The name of this company is called Cavendish Maxwell, to come to the unit and measure the unit size. So are you aware of that report? That the report that came out from you know, from the Cavendish Maxwell?
I cannot recall that.
Okay. Yeah, just to put that in context, actually it was the 24th of October 2019. So the Cavendish report measured the area to be as 1,571.85 square foot, which is a difference of 830.68 square foot from what was put in the SPA. The area measured is actually very similar to the area as measured by the DIFC on that email in 2017. It's just the variation is very small. So you know, I guess we're pretty much in agreement. It's just a matter of calculation of what constitutes the total area of the unit, because we believe that the total area should be the net area, whereas Damac believes that the net area should be the one taken into consideration, and there is also a portion of the total area, which is the common area, which we believe is not in the contract. So just to put that into context. I believe I'm done here. So I would like to thank you very much for being here today, Mr. Ali Kokar.
Thank you very much. Mr. Wheater, do you have any re-examination?
My lord, I don't.
No. Very well. Thank you, Mr. Kukar. That's the end of your evidence, and you're free to go. Thank you for bearing with us with certain interruptions. But we're finished now. Thank you.
Thank you, sir. Thank you, my lord.
Right. Well, I think that's the end of the business for today. Tomorrow we will start at 1 o'clock with Mr. Dwela Senior, Mr. Salem Dwela. Mr. Dwela, have you managed to take any further steps yet to ensure that we can go ahead with your father at 9 o'clock UK time? That's, I think, 10 o'clock Italian time.
My lord, my father is actually in Dubai at the moment.
He's in Dubai.
Yeah.
Sorry, you're in Rome, are you?
I am in Dubai as well. He just, you know, lives far away.
Very well. We'll start at 1300 Dubai time tomorrow morning. Is that right? 1300? Yes. Dubai time tomorrow morning with your father, and I hope all the technical problems have been solved by then. If you need to ask the court staff to help you, please do so. Mohammed, can you give any relevant help with the technical assistance from the court side?
Yes, my lord. I will ask Ajaz to assist.
Thank you very much.
My lord, there's just one final matter from me, and it may be that we play it by ear and see how we get on. But I was able to take instructions during the short adjournment for Mr. Dwela to consider his cross-examination. Would it be?
I missed after you said cross-examination. I missed it.
Given some of the technical issues that we've had today, and given your lordship's suggestion that we could potentially use Tuesday for this hearing, my has informed me that he could be finished with his medical appointment, so that if we were able to start, if we were able to take your lordship up on the suggestion of sometime Wednesday, we would be able to start at 12 o'clock UK time, which is 4 o'clock Dubai time. And my suggestion.
Is that?
I'm sorry, my lord.
Which day is that?
That's Tuesday.
Tuesday, yeah.
So, what I was going to propose is if we deal with, if we work on the assumption there may be some technical issues tomorrow, and we work on the assumption that we will do Mr. Dwela Senior evidence tomorrow.
You're breaking up again. I don't know why. Your microphone, maybe you're getting too close.
I don't know, my lord. I will try it this way. Am I still breaking up, or?
That's fine.
My lord, what we were going to suggest is that perhaps tomorrow's time, to allow for any potential technical issues and to allow for Salem Dwela to be assisted, tomorrow's time could be used for Salem Dwela's evidence. And then if your lordship is willing to sit on Tuesday, we could perhaps have an hour each on Tuesday for closing submissions. But I'm only making that suggestion I'm making that suggestion, but my solicitor has asked the indulgence that we could start at 12 o'clock UK time, because that would give him time to attend his medical appointment.
Well, I'll tell you what, should we see what progress we make tomorrow with the witness? If we finish him within an hour and a half or 2 hours, we could then just carry on into submissions, couldn't we, after a break of half an hour or so?
That's absolutely fine, my lord.
And if we find it's not working, then we'll decide what to do about the following day.
That's sensible.
Mohammed, can I just check with you? Is there any, if we need to go into the following day, into the Tuesday, is there any difficulty from the court's point of view?
I don't have anything that would prevent me from attending, but I will have to check with Cheryl and the rest of the court staff to see.
Could you do that maybe overnight and check? We may not have to do it, but just check that if we do get to that position, there's no difficulty with carrying on the Tuesday.
Yeah, okay.
And I assume, Mr. Dwela, that if we get to that position, you would have no trouble either. Is that right?
My lord, no objection from my side.
Very well. Well, let's try and finish it tomorrow, but we'll keep that possibility open. So meet at 1 o'clock, 1300 Dubai time tomorrow, 9 o'clock UK time. Thank you both very much.
Thank you, my lord.
Thank you, my lord.
Thank you.
Thank you, Mr. Weather.
Thank you, Waleed.